Santosh referred to the framing of the Constitution by our forefathers. They have given us a beautiful Constitution. It is a federal Constitution, though not strictly federal, quasi-federal, because apart from the power of the states, the Union has also the right under certain circumstances to take over even the administration of the state. That is under Article 356 of the Constitution. So, in this quasi-federal Constitution, the center takes the president and the governors, they have definite role to play. And at that time, the founding fathers never thought that we will have type of governors as we find today. The subject says ED CBI, money laundering and role of governors. Justice Hegde has referred to the role of governors. According to the Constitution, the governors have limited role, but they must be men of very high integrity, and they must be a role model for the people. In fact, though they do not have many powers because they have to act on the aid and advice of the Council of Ministers, they don't have very few instances where they can exercise their discretion. Otherwise, they are bound by the. But today, what is happening? The legislation passed by the houses, they don't give assent. Now under Article 200, when a bill is passed by both houses and it is sent to the governor for assent, he can either grant assent or withhold it for good reason, or if the legislation in question is likely to interfere with the power of the High Court, then only he has to refer it to the President. Or if the law is repugnant with any central legislation to make the state law effective, then it should have the assent of the President. But now we have governors who do not do anything, just keep the bills pending with them. Neither assent nor withhold nor send back. This is the situation, and some time back I have known some governors, they were just sending it to the President so that it will not come back. Though there was no reason at all for sending it to the President. Now otherwise Supreme Court clarified, you can't simply keep it. Then after keeping it for 2 years, then you send it to the President. And even after the second time when the legislature passes it, even then you don't give assent. What is this is happening in few states, not in all states. At the time of the Constitution, founding fathers generally thought there will be cooperation between the state and the center. But today, because of the situation where several states have opposition, parties opposed to the central government, therefore there is serious difference of opinion between the central government and the state government. Now this has to be somehow resolved. We have here to consider the various problems which are faced today. And it is very difficult to find an immediate solution to these problems. But let there be a debate, let there be consideration of the problems which we are facing. In fact, for the inaction or wrong action of the government, I personally feel, apart from the governors concerned who are at fault, the central government is also at fault, because governors are there at the pleasure of the president. They don't have any fixed tenure. They could be removed at any time. But we find in 3 or 4 states, though the governors are behaving totally wrongly, and in many cases Supreme Court came down very heavily on the governors for keeping the bills pending. And it is even thereafter, the central government doesn't take any action. That means central government is also party to it. Wherever the opposition is in the government, they want the governors not for operation or smooth running of the government, but to put obstacles in the way of the implementation of the enactments passed by the state legislatures. Now, this is a problem we have to consider. Now, more important than this is, there are investigating agencies under the central government. There are investigating agencies under the state government, under the control of the central government. The local police and the in fact in Tamil Nadu they have got the B.V.Acharya, Director of Vigilance and Anti-Corruption. And here, when it was with Lokayukta anti-corruption, though the Lokayukta himself did not have direct control over the police so far as investigation is concerned, but still, because it was under the control of the Lokayukta, position was much better. But suddenly one government thinks that in Tamil Nadu B.V.Acharya, directly under the control of the government, why not we also have it? So we have our ACB. I am one of those who oppose that measure because it was not proper for having taken away the power from Lokayukta police and invested with the ABC. Then, under the ABC, directly under the control of the government, and before registering a FIR, the competent authority's permission is needed. And competent authority is the Chief Minister of the state. Of course, when it was challenged before the High Court, they said we will not implement that provision because they couldn't support it. And this ABC continued. The opposition which was saying it is bad, suddenly they come to power and they not only don't withdraw this and again give it to the Lokayukta. On the other hand, before the High Court, the learned advocate very strongly supported this ABC and did not want it to go back to Lokayukta.
Not ABC, ACB. ACB.
ACB.
Anti-Corruption Bureau, not ABC.
So, what I am saying is, even the opposition party which did not want it, not only did not withdraw it, but supported before the High Court. However, ultimately, High Court party and this formation is back. It should go back to the Lokayukta. What I am trying to say is, when a party comes to power, they feel, and when a question comes, having more power to the government and police. They think they will be there forever and therefore continue. But ultimately they find they sometimes become victims of these things. Therefore, the point that I am making is, I have always held the view that the investigating agencies should not be under the direct control of the government. Because once it is under the control, we have seen so many wrong things happening, victimization and all other things. Now the question is, today there is a new problem because different states and unions have different governments. Today the result is in Tamil Nadu or Kerala or West Bengal. There is direct conflict between the central agencies and the state police or other agencies of the state. Now, Enforcement Directorate has proceeded against some cabinet ministers in the case against former Chief Minister of Tamil Nadu. Disproportionate assets case here. The case, after protracted proceedings, reached the stage of recording of the final statement of the accused under 313. After the prosecution is over, suddenly in the election, she again wins and becomes the Chief Minister. The moment she becomes the Chief Minister, though the case has reached the stage of 313 statement after prosecution was over, the Chief Secretary calls a meeting of the DVAC and says there are total wrong calculations in this charge of DVAC, therefore hold further investigation and correct all the mistakes so that you show that there is no disproportionate action. On the other hand, it is the reverse. No, that was, and they wanted me as prosecutor to take 6 weeks time to enable the DVAC to further investigate and file further report. I said, you can't do it at this stage. This is reached the stage of 313. But still, when I declined to take adjournment, the investigating officer directly writes to the court, please adjourn, I am going to hold further investigation. Whatever is the opinion of the public prosecutor, I am not bothered. Ultimately, to our rescue, the High Court passed the entire order of the Chief Secretary and it also passed the investigation, further investigation held so as to help the accused. So this is what happens when the investigating agency is under the direct control of the government. So we have to find a method, whether it is CBI or B.V.Acharya, above them there should be some independent overseeing body. In fact, one suggestion made is you give full power to the CBI. I said even that is dangerous. Political dispensations taking a decision, it's all right. But you can't say if it is police, it's a final that suggestion was made about 2 years back when the direct conflict between number 1 and 2 in the CBI itself, CBI director and CBI special director, each accusing the other of corruption, nepotism and concoction of evidence, thereby indicating to the world that we are also capable of this. And they were relieved of their duties and another next man was appointed to be in charge of director of CBI. and he had to be hauled up by the Supreme Court for directly violating an order of the Supreme Court. And he was given virtually day sentence by sitting in the court. So till the rising of the court, he was punished. He was number 3. So I said, this will show what will happen if they are given the full powers. The charges against the director was that the accused in 2G scam were coming to his residence. This is their way. So giving them full power is also bad. Therefore, the need is to have a independent agencies to oversee this. How do you have a independent agency? Now, Election Commission is supposed to be independent agency, but it is entirely appointed by the government. Supreme Court said no. Subject to law. The law is made, they said the central government will appoint. But no law was framed at all. Supreme Court said no. You frame the law, it is mandatory. And till then, the appointment shall be by a committee of Prime Minister, Leader of the Opposition, and CBI. This was the proposal, and that is to be till the law is enacted. Immediately, law is enacted by the central government. They said it is Prime Minister, Leader of the Opposition, and instead of CBI, a cabinet minister to be nominated by the Prime Minister. What is the object? CBI is eliminated. At least they could have said a nominee of the CBI, or at least, though not full proof, at least the Speaker or Vice President. Instead, they say a cabinet minister, and law is not in a hurry in the absence of the opposition. Not much would have happened if they were present, but there was no discussion also. And if normally we would expect Prime Minister and Leader of the Opposition to take opposite stand. But which cabinet minister will support the Leader of the Opposition, even if it is correct? So this is how even an attempt by the Supreme Court and suggestion of the Supreme Court to have an independent body is being thwarted by this one. Now this legislation is under challenge. I don't know what view the Supreme Court will. This much, so far as the conflict between the central agencies and state agencies directly contradict each other and working at cross purposes on the basis of political affiliation. But so far, our judiciary at least was absolutely independent. Nobody said that judge is given judgment because he is in favor of that particular party or this political party. The most unfortunate development as I could see is what has happened in Kolkata High Court 3 days back. A single judge directs a particular scam relating to admission to MBBS courses because there have been serious allegations. Investigation to be conducted by the CBI. Now the Advocate General opposes it, but still single judge says it will be by the CBI. Immediately the Advocate General rushes to the division bench and orally makes the request, and division bench stays the order of the single judge. Before the single judge, Advocate General, really surprising, he told the single judge, you are candidate for the next Lok Sabha elections and you will be given ticket by the ruling party. But clearly indicating that you belong to that party. Then, the single judge said, how could the division bench entertain an appeal orally without in writing? Therefore, the interim order of stay passed by the division bench is wrong. I am not going to obey it. Also, advocate says, give all the papers to CBI now itself, ignoring the order of the division bench. And in that order, he says, the senior judge in the division bench is supported by the local government, that is Trinamool Congress, and CM's nephew is a rising star, and therefore the senior judge is helping the ruling party. And he further makes an allegation in the order itself that the senior judge has called another judge of the High Court and has asked him to give certain decisions in favor of the nephew of the Chief Minister. To this extent, it is said that the senior judge is for the local government and local party, and the single judge is the Supreme Court must have been terribly surprised. And therefore, yesterday, though holiday, they held a special bench and they said, enough is enough. The entire proceeding that we stayed, and they have posted the matter tomorrow for hearing. And what I am saying is, our last hope was judiciary. If even in the judiciary, to this extent, there could be fight between the two judges, I think we are in for some serious trouble. Therefore, I think this is the most opportune time where people like us who are not affiliated to any political party but are only interested in the welfare of the people and the country, something should be done to change the entire system. As Justice Hegde pointed out, our entire attitude will have to change. I am glad that today, at last, the Prime Minister has said that don't glorify those who are convicted and who go to jail. That is what Justice Santosh has been telling all through. Why do you garland a man who is coming out of jail after serving the sentence? Today, at least, the Prime Minister has said it should be done. Therefore, friends, I have pointed out the problems facing, and I have also suggested the need of the hour is to have an independent overseeing agency. How it is to be done, it is for us to debate and discuss. And before concluding, because one of the subject is ED, may take few minutes on that. Enforcement, this Money Laundering Act, as the object of Money Laundering Act is good. That is, wherever there is proceeds of a crime, you commit a crime and have some proceeds. Now those proceeds are displayed as untainted money by others. Now that is to be prevented, and the idea of the enactment is wherever the proceeds of crime are in the hands of anybody, that must be got. Confiscation of that property or money, and also punishing those who help the parties or perpetrated the crime to benefit from the proceeds of the crime. that is the object. But actually, in practice, what is happening is, it is a case of harassment. Only 2 or 3 important points regarding this act. First is, just like FIR in other crime, here it is DCI or something. They have got a document under which the proceedings commence by the ED. Now that document, they say is a secret document. It will not be given to everybody. That shows what the charge against the person is. And with the EC, you arrest the person. And when a remand is sought, that secret document is available only to the court, should not be shown to the accused. And accused will not know what the charge against him is. And the law says, another provision, a bail can be granted only after the court is satisfied that the man is not guilty. Now, how can he say, when the ED asks for remand and shows this document, how can the accused, without knowing what the offence is, prove that I am not guilty, therefore I am entitled to stay? This is the other provision. The third provision, most importantly, section 50 of the Act, it says the ED officers can summon anybody, and whatever question they put, they must answer. It will be in the nature of a judicial proceeding, as much as both has to be administered. He will be liable for perjury. He is bound to answer all the questions. And after all this inquiry, then you say then they arrest him. And they say he is not cooperating because he is giving evasive answers. Thereafter, what they do is that section 50 virtually takes away the protection granted by Article 23 of the Constitution. You can't incriminate, you can't be expected to give incriminating material against you. Now, to supplement that, you bring this section 50. Because at that time, and Supreme Court says, at that time you are not an accused. You don't know you are an accused or a witness. Your statement on oath is recorded. And thereafter, he is arrested. Only thereafter, you get the protection under 20. And Supreme Court in the case of NDPS said, these officers who have all the power of seizure, arrest, investigation, charge sheet, but still they are not police officers, ED officers are not, so confession made to them is admissible in evidence. That's what the Supreme Court also said. This is the position. I am showing how they are trying to circumvent the law. Even here, circumventing law by government is very easy. No, the law says, by Constitution Amendment, the Council of Ministers should not exceed 15% of the membership. So, you can have only 34 ministers. Now, how to circumvent? Go on appointing advisors, political advisor, economic advisor, so many other advisors, and then about 35 or 40 chairmen of boards and corporations with cabinet right. The result is you have more than 78 persons of cabinet right, though technically it is only few. This is how we are circumventing the law, and that's why I say this enforcement, this Money Laundering Act is totally opposed to the fundamental principles of criminal law. So long as it really a man is guilty, it's all right, we don't mind. about innocent persons against you because of political other reason you are arrested? The Calcutta High Court matter yesterday, the Times of India has written an editorial speaking of the great danger before us. Friends, I have generally pointed out the problems facing us and also the solution so far as the investigating agency is concerned. You must have independent bodies to oversee their function. Thank you very much.